And this is a big news coming out of India. After 2 years of debate, India has officially abolished the colonial sedition law. What does this mean? That the Indian lawmakers have finally repealed IPC Section 124A. This section dealt with sedition. The British rulers had introduced it in 1870. It punished people for sedition. In simpler words, if someone spreads hatred or disaffection against the government, then he or she could be charged with sedition. The punishment, life imprisonment. Now, this law was never used against those in power, only against the people who opposed them. Journalists, activists, dissenters, they were all charged under this section. And this is why it was widely criticized. 1. It was vague. 2. It was widely misused. And 3. It violated the freedom of speech. This is what Article 19 of the Constitution says: everyone shall have the right to freedom of speech and expression. But sedition laws curtailed this right, so India has finally decided to do away with it. The new Bharatiya Nyaya Sanhita, or BNS for short, came up with an alternative. It replaced sedition with another offense. Let me tell you about it. Section 150 of the BNS deals with acts endangering the sovereignty, unity and integrity of India. Whoever does any act with the intention to cause disaffection towards the Indian government, B. incite violence against the government, or C. encourage any person to do any of these things, well, such a person can be charged under Section 150 of the BNS. The punishment, again, it's up to life imprisonment. But unlike the old sedition law, this one talks about intent. The punishment will depend on the intent and the impact of the act. In other words, the new law has 3 key changes. Number 1, it scraps the word disaffection. Instead, it talks about actual threat to the nation. Number 2, it removes the British colonial language. Honestly, this is a good thing. And number 3, it does away with the provision of sedition. Now, in theory, all of this sounds good, and we say that because sedition laws have no place in a democracy. They curtail freedom of speech. They violate basic rights. But this law did serve some purpose, like in cases of terrorism or when somebody is inciting violence against the state. So India needed a law to deal with such people, but it cannot be a law that is vague and open to misuse. And this is where the new law may run into trouble. For starters, the definition of the offense is still very wide. It all boils down to how the government and the courts interpret it. If there's anything that history has taught us, it is this: governments hate dissent, and this new law will still allow them to crack down on dissent. Arrest without warrant is still permitted. So is the punishment, which is up to life imprisonment, and we know that. Even the smallest criticism can be blown out of proportion. Just think about it. Sovereignty, integrity, these are not very clearly defined terms. What happens when a journalist questions a government policy? Can that be termed as an attack on the country's sovereignty? What if an activist calls the armed forces' action in Jammu and Kashmir as an attack on the country's integrity? You see the problem here? The scope of this law is still very wide. We acknowledge that the colonial hangover is now over, but will the new law be used with the same colonial mindset? That's something we must wait and see. The sedition law has been repealed, that's a fact, but its spirit lives on in the BNS. The new law may look very different, but its teeth remain intact. What India needs is a law that protects the nation from real threats like terrorism or incitement to violence. At the same time, it cannot curtail freedom of speech. Striking a balance between the two will be a challenge for the lawmakers and the judiciary. Only time will tell if they get it right.